The first case and the inaugural case for the 9th District Court of Appeals doing Zoom with a video conference of our oral arguments is State of Ohio versus Jacob McCormick. And the Court of Appeals number is 19CA0111502, and it's from Lorain County. So good morning, everybody, again. And is everybody ready to proceed? Can the attorneys hear each other?
Yes. Yes, and
yes, Judge.
Judges Teodosio and Hensel, can you hear everybody?
Yes, Judge.
Okay. Just everybody keeps their voices up if you don't care. Okay, well, you two know the rules, and it's the same rules that we were going to have if we were in our actual courtroom. 15 minutes each to present your arguments. And then obviously the appellant will let me know if you want to save some time for rebuttal, and I'll try to keep watch over that. And then the appellee, the state, will have 15 minutes. Okay, are we ready to proceed?
One quick question, Judge. You're keeping time, I'm assuming. Yes. How will you let them know when how far along they are? Are you just going to?
I'll just do it the old-fashioned way that I did. I did for 20-some years, and that is, you're getting down to your rebuttal time, you know. So okay. I'll let you know when you're getting close to your rebuttal time, whether you want to save it or not. But right, you need to let me know whether you want any rebuttal time, obviously.
One other matter in the other Zoom videos that I've done, just as like a housekeeping matter, if like when Brian's talking, I think I should probably put mine on mute because it eliminates some of that, you know, background echoing and things along those lines.
Well, I'm glad you thought of that, because that is something I wouldn't have thought of until we were getting it. And then I would have said, oh, maybe we need to mute this. Yeah. Thank you. I appreciate that. Sure. So Brian, did you hear that as well? Brian, can you hear now? What,
I can. Yes. Yes.
What did you hear though? What she was saying that maybe
I did.
Okay. Okay.
I
All
did.
Right.
Yes.
All right. Thank you so much. All right. We're ready to proceed.
Good afternoon, Your Honors. Giovanna Bremke on behalf of Mr. Jacob McCormick. I would reserve my full rebuttal time. Mr. McCormick was indicted on a 10-count indictment in the Lorain County Common Pleas Court with Judge John Moraldi. Out of the 10 counts, 2 were rape charges, 4 GSI, and 4 contributing to the delinquency of a minor. And he was convicted of those with the exception of count 2 rape. And there's 4 assignments of error. So the first deals with some jury direction and instruction or lack of instruction. So it's sort of two issues here. One is the jury came back on with a question, and the question was, we need to be unanimous on every count, correct? And this is sort of akin to a Howard charge question, but the judge in this case did not instruct on the Howard charge. Instead, he had crafted his own instruction and his own response. And the Ohio Supreme Court has explicitly given direction when juries are deadlocked and can't decide on the charges on how to instruct them via the Howard charge. That was not, yeah, go ahead.
Counsel, but the jury hadn't indicated that they were deadlocked at this point, had they?
You know, I think their question does indicate that they, you know, that they couldn't decide on, you know, on the counts because they're again asking, you know, do we have to? And that would, you know, obviously the jury isn't sophisticated enough to say, hey, we're deadlocked. But that question in and of itself is an indicator that they in fact were deadlocked.
What would you?
Go ahead, Judge.
Let's say that Judge Carr is right, and the question we need to be unanimous on every count correct is not an indication that they were unable to reach a unanimous verdict. Is there an argument being made that once the judge gave what appears to be a modified Howard charge, that was error? In other words, you either give it correctly or you don't say anything at all?
I would say yes, because there is direction on what should be said. So, and it's, pretty explicit what the verbatim language should be, and that wasn't given. So a modified instruction, again, sort of like what you're saying, there almost was a Howard instruction to the extent that it wasn't a Howard instruction. It wasn't the correct instruction. So, in essence, it really wasn't correct at all.
Well, counsel, I thought all the judge did was just tell them, yes, your verdict has to be unanimous.
Right. But, again, it wasn't, it didn't have the language, the additional language that the Howard charge would, but there was a response. So again, in that response, it would be, I guess you could say it was in essence a, Howard charge, but really not, in that it was incorrect in that language. My argument is obviously that there should have been a full Howard charge given.
Thank you.
The second part of that first assignment of error is that it's sort of an unusual situation in that the counts 3 through 6, which were the GSI charges, were instructed 3 different times to the jury. So on April, I believe it was April 11th, they were instructed on those counts that there needed to be a purpose element. And then right then on that day, the state corrected and said, no, that's error to include the purpose. And then the judge re-instructed them at that point. And then on April 12th, the next day, after 4 hours of deliberation, the state came back again to the judge and said, okay, that actually was correct, the original time. So they were again re-instructed and given re-instructions in the middle of their deliberations. Obviously, this is confusion, and again, the argument is that this confusion would have deprived Mr. McCormick the right to a fair trial. This is
Counsel, this is, when I was reading it, I was like, this is very confusing. And so I had several questions. I'll try to limit myself to just a couple here this morning. First of all, did the court provide counsel with written jury instructions to review prior to instructing the jury?
That's my understanding, yes.
And so nobody noticed any problem until, they didn't say anything about the written instructions. That's what I'm trying to say.
No, my recollection of the transcript, and I'd have to go back and look, but I believe what the prosecutor had said was that he didn't catch it on the written rendition until they were in the courtroom and the judge was instructing, and it just didn't sound right, basically, to him.
And this was all in regard to the GSI counts, obviously.
Right. So, and again, that instruction 3 times. This is obviously a serious matter. It's confusing, and I think when we talk about deliberations and the practicality, when I was preparing for this, I was thinking, I've never been a juror, but when you think about the way we know juries deliberate, you don't know when along the lines of their deliberations would they have made the decision about whether they're going to convict him on these counts or not. So they, during that first 4 hours, it's probable that maybe they made a decision based on, the wrong instructions, or maybe they made it after and we just don't know. So or maybe they just said, we're so confused, we don't know, and we'll just convict him. So I do think that is certainly deprived Mr. McCormick of the right to a fair trial. Second assignment of error is that is cruel and unusual punishment. And again, I'm asking you to use some liberty in the law here, because I realize this is, a matter. I'm asking you to use law from other scenarios, and interpret it into it. So I think we're all aware of the Roper versus Simmons case. It's a U.S. Supreme Court case, and it's a death penalty case. So again, not necessarily the same as here, but I think when you're talking about a death penalty case and being put to death, and this is a life sentence, there's some equivalence there. In that, what that case stood for is that when individuals are under 18, they are immature, unable to make these decisions, and that their brain's not fully developed. And again, a Kentucky court, Breadhold, expanded that to 21 years old. And what both of those courts in their reasoning said was, when you're young, either whether it be under 18 or under 21, again, you're immature, your brain's not developed, you're susceptible to peer pressure and emotional influence. And what we know about these offenses that Mr. McCormick is charged and eventually convicted of is that they are emotionally driven, and that an 18-year-old just simply isn't mature enough to handle such, serious consequence when their brain just isn't fully developed. He was just 18 at the time of these offenses, and now he's serving a life sentence and had no prior record before that. So again,
Well, he is eligible for parole after, 10 years?
correct. But again, with the possibility that that's not granted in all likelihood, maybe not even probable to be granted after that 10 years.
Counsel,
Yeah.
Counsel, you're going to be starting your rebuttal time. Do you want to continue on, or do you want to say
I'm going to quickly hit on the other two assignments
you.
of error. Assignment of error 3 is sufficiency. And again, there was actually what you'll find in the record is there was a written motion for Rule 29 acquittal, which deals with this exact issue. And that is the fact that that there wasn't enough evidence to show penetration and sexual conduct, where the victim in this case testified that there was no ejaculation, and what the attorney had argued, and again in a written motion, that it's not credible to believe that an 18-year-old there would not be ejaculation, and that proves that goes against the proof of the penetration and sexual conduct. And the fourth assignment of error, again, goes against credibility of the victim. And that's the fact that her story has changed. Initially met with the detectives and it was asked 12 times, was there any sexual conduct? And the answer was no. Then after pressure from her parents, had said that they had told a female detective that there was some sexual conduct, but then at trial, again, adds additional sexual conduct that was never disclosed previously. And again, it just goes against the credibility, and therefore the convictions are against the manifest weight of the evidence. So I would reserve the rest of my time.
Thank you. You have around 3.5 minutes. Thank you. Counsel for appellee.
Good morning, judges. Brian Murphy, Assistant Prosecuting Attorney, Lorain County Prosecutor's Office. I'll be brief because the state does not believe that there's any issues in this matter. With regard to the first assignment of error, Judge Carr, from the state's perspective, you are correct. This was not a Howard charge situation. The jury did not communicate at all to the trial court that it was deadlocked, that it could not reach a decision. It simply asked a question, asking if it had to be unanimous on all counts. There was no reason for the trial court to give a Howard charge, let alone plain error in not doing so. From the state's perspective.
Did the court give a modified type of Howard charge?
No, Judge. No. The trial court answered the jury's question, perhaps with more wording than it should have, but the trial court simply answered the question. With regard to the jury instructions, I think it's important to note that the record reflects that the trial court caught the error, not the state. The trial court caught the error. with regard to any allegation or any assertions, the jury instructions are confusing. Jury instructions inherently are probably confusing to the 12 people who are back deliberating. If they're confusing to us, they're probably going to be confusing to the jury. What's more important than whether they're confusing is whether they were correct. That's the important consideration for this court, is whether they were correct. Because what the argument basically from Mr. McCormick is that the trial court erred by rectifying an error, meaning that the trial court, from Mr. McCormick's argument and perspective, should have let an error stand. That does not make any sense.
Well, can we go over these jury instructions a little bit? I got very confused in reading it. So they started out, written instructions were given to the attorneys. Is that correct?
I believe that's correct, Judge.
And then after the judge had instructed the jury, then you're saying the judge found, I thought the prosecutor found it a potential error.
I believe that the trial court determined there was error. I'll admit that I may be misrecollecting that.
Okay.
I
Well,
I don't think that.
Go ahead, Judge Hensel.
I think at least the brief seems to say the state said, Judge, there's no purpose in that, and so he instructed, and then the trial court caught the error the next day.
Correct.
Right.
That's
the way I understood it too. Thank you.
okay. So what? I guess I'm jumping ahead to the next morning when the
Well,
judge.
I would like to, if you don't care, I would like to go back to just
Sure.
get this in order as it happened.
Sure.
Okay.
So
So they were instructed, and when you're talking about the gross sexual imposition, you're talking about instructing them that purposely, they were instructed that they have to, because it's strict liability, but it's purposely in regard to sexual gratification.
correct.
Okay. So they were charged correctly to begin with,
Right.
but the prosecutor then indicated that there was a problem because purposely wasn't involved.
I believe that that's correct.
Okay, so then the judge corrected, I won't say corrected, modified the jury instructions then to say, I misspoke. You shouldn't consider purposely.
He corrected it to say you should consider purpose.
No. I'm talking about the first day.
During the initial jury instructions. Yes, Judge, correct. And
So
then
the jury was instructed to use purposely with sexual gratification, then was instructed not to use purposely with sexual gratification. Then the next day, the judge came in and said, hey, that was a mistake. The second one was a mistake. You are to consider purposely. So the first instructions I gave you were correct.
You are correct in that timeline.
Okay. But by that point, the jury had already deliberated several hours, right?
You're right, Judge.
Under incorrect instructions.
You're right, Judge. But then look at what the judge said. The trial court went on, and I'm reading from my statement of the case. The trial court went on to tell the jury that if it already had found McCormick not guilty of any of the gross sexual imposition offenses, it didn't need to reopen deliberations regarding those counts. That's what the trial court told the jury. The jury's, in fact, that's probably the real error here, is the trial court telling the jury not to reopen deliberations, because it gives the impression that once you come to a conclusion on a charge, that the jury can no longer go back and revisit it, which it could take to extend to other counts. Mm-hmm. That's probably the real error here. But the trial court definitively told the jury, if you've already found him not guilty, then don't even consider those counts again. So that takes care of any of the concerns that Mr. McCormick raises here, that we don't know if he's already been convicted of these counts, they had made a decision on wrong instructions. The trial court told the jury, don't go back to reconsider those if you've already found him not guilty. So that alleviates any issues with regard to what Mr. McCormick has raised here. The jury instructions are supposed to be correct. In the end, they were, and there's no legal authority cited by Mr. McCormick to say that the trial court was wrong to make sure that the jury was considering the proper instructions, was properly instructed, considering the correct law, that's what gave rise to a fair trial here and a just verdict. With regard to the second assignment of error regarding cruel and unusual punishment, the record below provides absolutely no basis for finding that the 10 to life sentence constitutes cruel and unusual punishment. I believe that the defense counsel made a two-sentence argument regarding cruel and unusual punishment. There is no record on the from the trial court below or even offered in Mr. McCormick's brief that would allow this court to find cruel and unusual punishment. And the state sets out under federal law, under Ohio law, the different tracks and the different considerations that need to be addressed, and Mr. McCormick addresses none of them in his brief. The General Assembly defines punishment after evaluating and establishing public policy. It's not for this court to legislate from the bench. Mr. McCormick's 18. He's subject to the 10 to life prison term as his sentence. It was mandatory. It was the only sentence that the trial court could impose. There was no error in doing so. With regard to the third assignment of error and the sufficiency of the evidence regarding the rape charge, basically the argument has a lot of credibility arguments to it, which of course are impermissible to consider on a sufficiency argument. It also incorporates ejaculation as an element of the sexual conduct, which in this day is an unfathomable consideration. In 1993, the 8th District called it ludicrous. We are now 27 years past that, and there's an argument being made to this court. That argument has to fail. With regard to the manifest weight, the jury had the opportunity to consider the victim's testimony and also the defendant's testimony, and it chose to believe the state's version of events offered primarily through the victim's testimony as opposed to the defendant's story. It shouldn't be very surprising that a 12-year-old might not have immediately revealed a sexual relationship with a much older male, but that's what the testimony from the victim indicated. That's what the evidence revealed in the form of text messages. And what we had here was a 12-year-old girl. She wasn't 12 at the time, but testifying, but 12 years old when the incidents occurred over a 4 to 5 day span. She's describing and having to relive these events to strangers sitting in a jury box, to a prosecutor in front of in front of Mr. McCormick, his counsel, a judge, and what Mr. McCormick is essentially saying is that she concocted this entire story, and that he should be his self-serving testimony, in which he basically simply had to deny everything that she said, the victim, would be what saved the day for him. This was not a case in which the evidence was so lacking that this court should overturn his conviction. If the judges don't have any other questions, the state asks that you affirm the judgments of the trial court and Mr. McCormick's convictions and sentences.
Thank you.
Thank you, judges.
Appellant?
Yes, I just want to address a few things quickly based on what the state just provided. The defense counsel at the trial court level did address the cruel and unusual punishment. I'm looking back transcript, page 500. He did bring that up to the court. It was raised. the fact that it would be a cruel and unusual punishment. And as far as the jury instructions go, I think there was a comment that what I'm suggesting is that it's incorrect, that it was incorrect to correct the instructions, and that, that what I'm implying is that the incorrect instructions should have stood. That's not what I'm implying. There is a remedy for that, and it's a mistrial. And that's what happens when there's, not a fair trial. And that's what the assignment of error suggests, that at that point, the jury instructions were so confusing that it warranted a mistrial. And I'm not suggesting that the incorrect instructions should have stood. What I'm saying at that point is that, the fact that they were instructed 3 different times warranted a mistrial at that point. So again, what I'm asking that the court find on the 4 assignments of error and reverse the convictions. And thank you for accommodating us today on Zoom.
Well, thank you. Thank you for making yourselves available. These are difficult times for everyone. We thank you both for your arguments. The same procedure will follow. The court will make a decision, and it will be written, and it will be sent out to both sides. So I appreciate everything. And please be safe and take care of yourselves. And maybe we'll see you again on Zoom.
Yes.